All right, ladies and gentlemen, we're back with chapter 14. Chapter 13 was about the trial process. So, at the end of a trial, a person is either convicted or not convicted, or they may plead guilty. If they're found, in the case if they're found guilty, or let's say they enter a guilty plea, then the next stage is sentencing. And that's what sentencing and possibly appeals if they want to appeal the verdict. And that's what chapter 14 is about, sentencing and appeals. As an introduction, the chapter covers sentencing, appeals, and habeas corpus, which is another means of challenging your confinement per post trial. So that's like the habeas corpus is like it's like the last ditch effort to change the verdict or to get another opportunity. Um, a brief history of sentencing in the United States. And what I will say, United States, of course, ingrained in the DNA of the United States is racism and bias. So it's hard to talk about the criminal justice system without talking about it. As a matter of fact, the criminal justice system is probably the number one tool used to further racism and white supremacy and bias in America. That's what America's built on. Now, I love America, but when you love something, you challenge it or you challenge it to get better. So a lot of people say that's anti-American. I'm not anti-American. I'm just stating the truth. These are the facts. It's not really up for discussion. It's not up for debate. This is what America is based on. So, in talking about America, it's good to be critical um, to someone you love. If you love someone, you want to correct them. That's how I feel about America. Correct it. Let's get it right. So a lot of stuff we're talking about is, the background is kind of racist, and especially when we're talking about sentencing. So before I wanted to preface this next section by saying that. So a brief history of sentencing in the United States. The English system of harsh criminal punishments was brought to the United States. In the United States, in the 19th century, that's the 1800s, emphasis was placed on incarceration, rehabilitation, and indeterminate sentences. In the 12th century, I'm sorry, let me see, in the 20th century, I'm sorry, that's 1900s, there was a shift to what we call determinate sentencing, where people knew when they were going to get out. It was like a definite, this is how many days you're serving. And we'll talk about the difference between determinate and indeterminate sentencing later on. Um, in the last several years, there has been a modest movement towards community based services for offenders. So, criminal punishment. A penalty does not necessarily constitute criminal punishment. Um, a criminal punishment triggers various constitutional rights and protections. So the Constitution, there's also a part of the Constitution that controls and I guess sentencing and punishment. So there are actually controls put on that part too. So even if you're convicted, you still have rights even if someone is convicted. The purposes of punishment. And they will talk about several purposes of punishment, and different books will say different things, but this is what this book says, and I think it's pretty accurate. There are several purposes of punishment. You have retribution, which is essentially like just desserts. You did wrong, quid pro quo. I mean, you did wrong, so we're going to do wrong to you. You have deterrence. That means whatever your punishment is meant to, one, deter you from repeating the crime, and two, deter all others that may be thinking about doing what you're doing from doing it. Because if they see, that's the one thing about public trials. Is one reason it's a right is not just to protect the person that's being accused and protect their rights. It's also an opportunity for the court system to put everyone on notice that may want to commit crimes, that this is what can happen to you. This is the example. You'll go to jail or you'll be punished. So that's deterrence. Then you have what we call incapacitation. When someone is done something so heinous or they're so dangerous, we have to incapacitate them, meaning that you essentially kill them. That's the death penalty. And then two, you have restitution, and that's the portion where we're trying to make a victim whole. In other words, something's been done to the victim. The victim's lost. The TV was stolen. The house was broken into. Now we want to make sure they get that back, and they get at least a money value for what they lost back. And then last but not least, we have restoration. So restoration can work both ways. You can actually restore a victim who's had something taken from them, and you want to restore them. But it also applies to the criminal or the defendant themselves. Because a lot of times, people, what I've learned is people aren't, a lot of people I deal with and I represent aren't inherently evil. They don't do bad things because they're bad people. The situations they're in and the situation that they may be in or the environment they're in leads them to committing crime. Especially, you have thieves, you have people out there that go in the grocery store and they steal. Like the question then becomes, why are you stealing from Walmart? When you have a single mother with no kids, she can't get a job, or this and that happens in her life. Um, she's desperate. She's trying to feed her children, and she has no means of doing it. But if she can just go into Walmart, get a couple food items and make it out, put stuff them in her shirt and make them out and make it home. She can make some cold cut sandwiches for her kids so they can eat something and not go to bed with that bottomless pit feeling and that empty stomach feeling when they go to bed. She can feed her kids. So sometimes when it comes to restoration, sometimes we have to say what made this person commit this crime. Is there any way we can help them so that they won't come back? That we can help make them whole or get them on the right path so they can have earning potential, so they can get a job or put themselves in the best position where they won't have to get to the point where they have to get to the desperation point where they have to steal. So that's restoration. Some people are addicts, drug addicts, and they commit crimes because the drug they're addicted to is now made them steal mama's TV, so they can get a crack rock. So the solution would be maybe to help them get off of drugs, to put them in detox, to put them in drug counseling programs, so they may not commit this crime again. So that's restoration. Types of punishment. Criminal punishments include imprisonment. That's what we call active punishment. You got fines. That's where we take money out of your pocket. We got probation. And sometimes probation can be the variation between certain imprisonment and fines and other things. But probation, and we'll talk about that. You have intermediate sanctions, which is usually probation with something extra on it, some type of extra sanction or extra thing that has to be done by the probationer. And you have restoration, and that's where, of course, I just talked about restoration. Well, I'm sorry, I said that wrong. We have fines, probation, intermediate sanctions, and then, of course, yeah, intermediate sanctions. And then we have capital punishment, and that's type of punishment where you don't come back, you're on death row, and that's it. So, approaches to sentencing. There are various approaches to sentencing. You have determinate sentences, and we'll talk about what that means. You have mandatory minimums. We'll talk about what that means. And then you have what we call indeterminate sentences. And then you have presumptive sentences. So we'll talk about what those mean. Now, the judicial sentencing process. Just to give you a brief background I'll go into it and then we'll talk about it. In the judicial sentencing process, in most jurisdictions, a judge is required to request a pre-sentence report from a probation officer. The judge conducts a sentencing hearing at which the defense attorney and prosecution argue for a favorable sentence. Um, or a non-favorable sentence. So the defendant has the right to make a statement at the sentencing hearing. Guess who else has a right to talk at the sentencing hearing? The victim, or sometimes if the victim is dead, the family of the victim. So the victims get to be heard too. So remember, they have a voice in this. So it's in North Carolina. Normally, we go to trial or we plead guilty, and sentencing is like directly after. Sometimes, depending on how long the trial is, sometimes the judge will break and say, "Let's come back tomorrow for sentencing." Because a lot of times at the end of a trial, there's a lot for a judge to mix in their head before they sentence a person. So let's see here. Sentencing guidelines. And well, let me get back to North Carolina. But the, the judges at that point, after either a trial or a plea, normally with pleas, the judge sentences right there because they haven't, been subjected to a long trial. So we just go up there and we say we plead guilty to whatever it is. And there's usually guidelines that determine how much time or what type of punishment the judge can give. And we'll talk about guidelines and why. But the judge has to consider that. So the judge can't consider things outside of it, but they have to sentence them inside that box. Um, Sentencing guidelines. The Federal Sentencing Reform Act of 1984 established the U.S. Sentencing Commission. The commission drafted guidelines to be followed by judges and sentencing offenders. The reason we have sentencing guidelines, we're going to go back to that birth defect of America, is racism. At one point in time, it was almost illegal to be black and doing anything. So that's what created the convict leasing system and people getting arrested and black people who were newly freed slaves that were out here just trying to make a living and be free. Now they really got put back into slavery because now their existence was almost illegal. So if you could arrest black people, or you can now put them back in the system and make them slaves again. Because I know you've heard watching the 13th Amendment documentary, the 13th, that slavery really was never abolished. Actually, slavery right now is alive and well. If you look at the criminal justice system and the number of people incarcerated or on probation, actually there are more people incarcerated or subjected to 13th Amendment slavery now than were slaves during the pre-Civil War era. So it's crazy. The numbers are staggering. As a matter of fact, in America, um, the American population only makes up maybe 10% of the entire global population. So if you count every human on the globe, the America makes up 10% of that. So there's a whole 90% of people in other countries left, right? But guess what? We actually make up. So in America, we have 25%. That's a quarter of the globe's incarcerated people. That's crazy. So we're only 10% of the global population, but we we have 25%, a whole quarter of the globe's entire incarcerated number of people. So we incarcerate people more than any other country. So we call ourselves free, but there are a lot of people not free. So I think there are freer countries out there. We're the land of the kind of free and home of the brave, right? So it is kind of a crisis. So what happened is the reason we had to have sentencing guidelines is because how do you think most judges looked back in the day? They were white males. So when it came to sentencing, you had bias that came into play. So now for the same crime, a guy who is not black um, would be sentenced to to maybe probation, or I'll just do community service, as opposed to the black guy with the same record, committed the same crime, being sentenced to like years in prison. So there was room without guidelines. There was room for bias. So that's really the reason why we now have guidelines. Um, Sentences under the federal guidelines are based on a formula that reflects the seriousness and characteristics of the offense and the criminal history of the offender. So this is all pretty much all sentencing guidelines. I even talk about North Carolina sentencing guidelines. So that's the best example I have. So you have essentially a sheet of paper that is the guideline that represents the sentencing guidelines. Now, every crime is classified. What that means is you have these categories of crimes, and they go from the bottom of the sheet. Let's say if we go to the left margin, the far left margin of the sheet, all the way at the bottom. What you have at the bottom, you have the lowest classification of crimes, and so the least serious crime starts at the bottom, and you work your way up to the categories until you get all the way to the top. So in North Carolina, we classify our felons from we have Class A felons all the way to Class I. So do the alphabet. So in North Carolina is A, B1, B2, C, D, E, F, G, H, and I is the lowest. So a Class I felony is the lowest felony in North Carolina. So when you see this sheet, if you start at the top, it goes A, B1, B2, C, D, E, F, G, H. I is the lowest. So Class I felonies are those felonies that are literally right above a misdemeanor. So if you start from the bottom of the page, you have I, and you're working your way up to seriousness, all the way up to A. That's on the far. If you can imagine, that's the far left side of the page. Um, so that's the classification of the crimes, and crimes are classified based upon their seriousness. So a Class I felony might be felony possession of marijuana or something like that. So you got too much weed on you, so it's a felony. Or a class H might be like felony larceny or something like that, where you stole something you weren't supposed to have. All the way up to class A, which is murder, capital murder. You know what I mean? So that's how the sheet looks on the left hand side. Now that's one variable. So the first variable is the classification or the seriousness or the characteristics of the crime. The second variable that goes into determining how a person is sentenced, you start at the top of the sheet and from the far left, you now from the left being the what I'll say the lowest criminal record level, all the way you work your way across the sheet to the right where we have the highest record level. So at the top of the sheet, we're now considering this person as an individual and what their criminal record is, not their race, not their gender, but what their criminal record is. So of course, the one thing about that's the reason you want to keep from having a criminal record is that's a paper trail and it goes with you forever. Once you're convicted of a crime, unless it's subject to being expunged at some point in time. It is what it is, and it's going to be there. So when you get convicted of a crime, now you got a crime on the books. Now, any other crime you're accused of and you're in court, uh, that crime is used against you, not saying you're guilty. But when it comes to sentencing, if you're found guilty, you having that crime on that criminal conviction on your record is now something that moves you further to the right at the top of that page. So in felony sentencing, we have level one, which means pretty much no criminal record, or slight criminal record, maybe a low level misdemeanor offense or something like that. All the way to level two, three, four, five, and six. Six being all the way to the from the left all the way to the right side of the page, being the worst. So that means your criminal record is so bad that's it. Six is as far as you can go. So if you can imagine a sheet of paper, you have uh, you have I felonies all the way through A felonies going from the bottom of the sheet up. Then in that corner, you have the lowest record level or criminal record level all the way to the worst criminal record level going from left to right at the top of the sheet. So where they intersect, where a criminal record level intersects with the classification of the crime, that's where you're going to be sentenced. So the sheet has a whole bunch of blocks, and these blocks are the intersections. In those intersections within the blocks, then you have another level of sentencing where you consider other variables. You consider whether the person is going to be sentenced in that block in the presumptive range, which is the middle, meaning all else being equal. You have the aggravated range where there's something about the crime itself, the way they did it, or something they did that makes it where they're going to be sentenced a little bit harsher within that box, however, but they're going to be sentenced harsher because there's an aggravating factor. And then you have a mitigated range, which is where this person has done something to mitigate the situation. They've apologized, they assisted law enforcement, they gave no resistance, or they essentially assisted in the crime with letting law enforcement know what happened, or they snitched or something like that. But that's considered in the mitigated range. So within the box, so you have these blocks. You have this page with uh, with six uh, with six columns, of course, going across, and then you have H through I rows going up and down. So you have these intersections, these blocks where they meet, and a person's sentenced in each block, and within the block that they're going to be sentenced. So let's say if you're in North Carolina, if you're a level one, meaning you have no prior convictions, and you're accused of a class I felony, we go to class I. That's the level of crime. Then we say, well, this person is level one. We go level one, and we go down to where the boxes intersect. And within that box, that's where you have to be sentenced. Now, within that box, of course, you have the mitigated range of sentencing, a presumptive range, all else being equal. No mitigators, no aggravators level of sentencing, and then you have the aggravated level of sentencing. I mean, there's something about the way you're alleged to have committed that crime that aggravates it or makes you have to be sentenced a little bit harsher, but within that box. Um, so that's how structured sentencing works. So essentially, the two main variables you're looking at. You're looking at the classification. We'll say three. You have the classification of the crime and your criminal record as the two main variables. But then we have other characteristics for how you committed the crime that can also be considered once you have the intersection between those two variables that can make it worse I mean, better or worse within that box. So that's the nutshell of how to explain it. Um, Okay, the judge employs a sentencing grid. That's what I just talked about, the grid, and is required to sentence a defendant within a narrow range where the defendant's criminal offense and criminal history intersect on the grid. Judges are required to document the reasons for criminal sentences and are obligated to provide specific reason for any upward or downward departure. So if you're gonna sentence them in a mitigated range, you gotta say why. You gotta list the mitigating factors. If you're gonna sentence them in the aggravated range, you have to list the aggravating factors. As a matter of fact, anything that aggravates a sentence, there's a Sixth Amendment right of notice. So a judge can't just sentence you in the aggravated range without the aggravating factors being without the defendant being notified that there are aggravating factors being accused. Now, mitigating factors are different. We can walk into court as a defense and present the mitigating factors right there. But aggravating factors either have to be agreed to in sentencing in the plea bargaining process, or the defendant, if they're not agreed to, the defendant at least has to be placed on notice that, hey, you're going to be sentenced in the aggravating factor, and here's why. Here are the aggravating factors. So that's the Sixth Amendment right to essentially know what's going to make it worse. Um, so several recent U.S. Supreme Court decisions have held that it's unconstitutional to enhance a sentence based on facts found to exist by the judge by preponderance of the evidence rather than by a jury beyond a reasonable doubt. So even to aggravate it has to, like, so if you're being sentenced, let's say whether it be especially after a trial, those aggravating factors must be found beyond a reasonable doubt. So that means not only does the jury convict you of the crime, but they have to find the aggravating factors, or the jury must have found the aggravating factors beyond a reasonable doubt before the judge can even sentence you on the or aggravate your sentencing. So it must be supported by facts, and the jury must have found as such. Um, the U.S. Supreme Court also has ruled that the sentencing guidelines are advisory. The appellate court should examine whether a judge's sentencing decision is reasonable, whether it is inside or outside the guidelines. Um, Determinate sentencing. Now we're going to talk about the type of sentences. Determinate sentences possess the advantage of providing for predictable, definite, and uniform sentences. The federal government introduced mandatory minimum sentences in the Anti-Drug Abuse Act of 1986 and its 1988 amendments. So what determinate sentencing means that there's an end date. So in North Carolina, for misdemeanors, misdemeanor cases are sentenced determinately. So of course with misdemeanors you can't get more than like 12 months or something like that in jail. Misdemeanor sentences in North Carolina are given out by days. So if you're found guilty of a high level misdemeanor, which would be an A1 misdemeanor, and you're a level 3, which is the worst sentencing level, same grid, but it's different. It has less. So a misdemeanor, you have the and levels of misdemeanors, you have uh, class 3, which is the least, class 2 higher, class 1 higher, and class A1 highest on the left hand side, going up, and then going from left to right, you have the sentencing, the record level being record level 1, meaning no convictions, record level 2, meaning anywhere between 1 conviction and 5 convictions, and then level 3 being 5 convictions or more. So those are the sentencing levels for misdemeanors in North Carolina. So what happens if you're a level 3 for sentencing purposes, I mean you have a level 3 conviction a record on a record of convictions, um, and it's a class A1 misdemeanor. That means where the A1 intersects with the level 3, the highest sentence you can get is 150 days. So if a judge sentences you to 150 days, that is determinate. That means if you start today and you don't have any credit already applied, meaning you haven't already been in jail, that means if you can count 150 days, you can almost scratch off You see in the jail where they scratch off and they slash through. That's every 5 days. If you can literally count 150 days, and in 150 days, roughly 5 months, I'm getting out. That is determinate. In felony court, it is indeterminate, meaning you are given a minimum, so you have to at least serve this amount, and a maximum. So you're going to serve somewhere between that minimum and that maximum. Normally, they start you out at the maximum, and you work your way down to the minimum. In the jail, and the prison can determine that based upon your behavior. So that is a determinate sentence. Determinate sentence is when it's definite, and you can almost predict exactly the day you're getting out. So if you're sentenced to 150 days, it's 150 days. Um, in contrast, indeterminate sentencing is, like I said, is sentencing where you're sentenced in a range. There's a max and a min, and you're gonna serve the time you're gonna serve is gonna be somewhere in between that. So that's indeterminate sentencing. Cruel and unusual punishment. The Eighth Amendment to the U.S. Constitution is the primary constitutional check on criminal punishments. The U.S. Supreme Court has ruled that the prohibition against cruel and unusual punishment applies to states as well as federal government, and virtually every state constitution contains similar language. What that means is, what they can do to punish you, even if it's capital punishment, is limited. It also what cruel and unusual punishment means basically is also that the punishment has to be proportionate to the crime. So if you're charged with taking a piece of candy from a convenience store, a nickel piece of candy is worth a nickel, and they can't give you 20 years for it. So in other words, and they can't give you death for it. So in other words, the sentence has to be proportionate to the crime itself, and that's kind of solved through structured sentencing. Anyway, that not even kind of is solved through structured sentencing. Methods of punishment. Courts have not limited probation, or not have not limited the prohibition on cruel and unusual punishment to acts condemned at the time of the passage of the Eighth Amendment. Cruel and unusual punishment is an evolving concept. So, back in the day, firing squads were cool, but it's been found that is now cruel and unusual punishment. Now, most states, the means of execution is usually either the gas chamber or lethal injection. So they're no longer hanging people and no longer like doing firing squads or beheading people like they used to do. The death penalty historically has been viewed as a constitutionally accepted form of punishment. Cruelty requires the intentional infliction of unnecessary pain, or pain and what do you call it? Infliction of pain or dismemberment or something like that. So essentially, they want, so if you're going to be punished via execution, they want to make sure that all your body parts are attached. So no more beheading and stuff like that, or stretching a neck or hanging a person. Capital punishment. Judges have been particularly concerned with the proportionality of the death penalty, especially from a racial standpoint. In Gregg v. Georgia in 1976, the U.S. Supreme Court approved a Georgia statute designed to ensure the proportionate application of capital punishment. In weighing states, the jury is required to find that aggravating circumstances outweigh mitigating circumstances. Non-weighing state, and that's in order to inflict capital punishment. In non-weighing states, so by weighing, that means they're weighing aggravating factors versus mitigating factors, and if aggravators outweigh mitigators, the person is sentenced to death. If mitigators outweigh aggravators, they're just gonna get life in prison. Um, in non-weighing states, they provide that the death penalty may be imposed once the jury finds any aggravating circumstance. The aggravating circumstance is to be evaluated in the light of the totality of the evidence. The death penalty may not be imposed for rape or robbery, and on juveniles and mentally challenged individuals may not be subjected to the death penalty. So that's essentially what the law says. So juveniles, no matter how heinous the crime, are not going to be subjected to the death penalty. and you essentially can't get the death penalty for any crime that doesn't involve the death of another person. So even though rape is a very bad crime, it's unconstitutional for them to now sentence you to death for rape or robbery. Um, and also, if you're mentally incapable or you have a mental handicap, they can't sentence you to death in that situation. Um, let me see. Okay. All right. The Eighth Amendment and sentences for a term of years. The U.S. Supreme Court appears to have accepted that the length of criminal sentences is the length of a criminal sentence is the province of elected state legislatures, and that judicial intervention should be extremely rare and limited sentences that are grossly disproportionate to the seriousness of the offense. So, what that means or what that says is, of course, legislatures essentially create sentencing grids. So that's like a legislative made grid. So they determine where you're going to be sentenced, the classification of crimes that's done by the state legislature. So the legislature who makes the laws at the behest or at the ordering of the people because they're elected, they make the laws on behalf of people and the sentencing grids on behalf of the people, and the judges are just supposed to apply it. So the judge, so what structured sentencing does is it kind of takes a lot of the judge's discretion out of it. Now there's still a little bit of discretion, but not a lot. So not to the point where it's going to be where people are going to get unproportionate sentences or be unfairly sentenced. Um, Yeah, okay. Equal protection. Judicial decisions have consistently held that it is unconstitutional for a judge to base a sentence on a defendant's race, gender, ethnicity, or nationality, and that's equal protection, of course. Um, in regard to laws that do not discriminate on their face, a defendant claiming that his or her sentence is discriminatory in violation of the Equal Protection Clause must demonstrate both a discriminatory impact and a discriminatory intent. So there we go again. That's the hard thing about proving discrimination. It's not just that you prove that it looks discriminatory, like look at the numbers, more black people are getting this and or getting that, but you must also prove intent. You must prove that the person that is sentencing is doing it with an intent, with a racist or biased intent. And even so, most people would say, well, it's proven just by the numbers, but the law won't let it be proven just by looking at the numbers and what's happening. It has to. You also have to have something else that shows that they're racist. And most people that, if they are racist in the judiciary, they're not out here calling people the N word or doing stuff that's remotely racist or doing something during the trial that shows they're racist. So it's super hard to overturn or show that a judge is being biased or racist. So because it's not because of, so of course you can show that there's a discriminatory effect, that there's obviously discrimination because of numbers, but you can't prove, it's harder to prove because you got to also show that there was an intent. So sometimes they say, well, that's just the numbers, it's just how it is. It doesn't mean he meant to do it or he's racist. So that's why it's hard to prove discrimination in these cases because of that last prong. Um, Okay, criminal appeals. So we talked about sentencing. Now let's talk about appeals. The federal government and all 50 states accordingly provide an appeal as a matter of right for felony convictions and misdemeanor convictions. But usually misdemeanor convictions just go to a new trial court or jury trial court to be tried de novo, a new trial. This appeal generally is an intermediate appellate court. So when we appeal from superior court or felony court, we're usually appealing to an appellate court or what we call an intermediate appellate court. So even in the states have courts of appeals, state courts of appeals. And then from there, they go up to from a court of appeal to either another court of appeal above it or maybe directly to the state Supreme Court in states. Um, the appeal generally is to an intermediate appellate court. A second discretionary appeal may be filed with the state Supreme Court. Saying it applies the same way in federal court. The U.S. Supreme Court has held that doing an appeal as a matter of right, an individual possesses constitutional rights. And sometimes, if it's based on a federal constitutional issue, even a state court, when you appeal all the way to the state Supreme Court, you can appeal from there and ask that the the United States Supreme Court hear the case if it's a matter of federal or constitutional question. So they may choose to take the case. Um, as a matter of fact, the Terry case we talked about earlier on, and I think chapter 4, we talked about stop and frisk. If you notice, that case is called Terry v. Ohio. That means there was something that happened in Ohio with Ohio law enforcement, where a person was found guilty in state court, and they ended up appealing, and they felt like it was a matter, a constitutional matter or federal matter that they should consider, and the court actually rendered a decision on it. That's why. So the Terry v. Ohio is a United States Supreme Court case, but it started in a state. So it didn't start with it didn't start with federal prosecution. So you see that the court of last resort in America altogether is the United States Supreme Court on the federal level, and really sometimes the state level, because from the state you can actually appeal. Now that doesn't mean they're going to take your case, because they're very choosy about what cases they take before they grant certiorari. And granting certiorari is when they say we're going to take the case or we're going to hear it. Um, Okay, in general, an appeal may be filed only following a final judgment. In some isolated instances, an interlocutory appeal may be filed prior to the final judgment, where it would be too late to wait for a final judgment. Appellate courts examine whether an error is harmless. Plain errors are so serious that they are reviewed despite the fact that the defense attorney did not raise the issue at trial. The violation of fundamental constitutional rights results in automatic reversal of a verdict. A new legal rule that is established on appeal is fully retroactive. That means it applies to everything happened before it, to all cases that have yet to be filed, and to all cases or appeals that have been filed. Um, and in some situations, even if they may reverse a verdict and actually enter a new verdict, or in some situations they reverse the verdict and they order like a new trial, or order the court to do it, order them to do it again. So it just depends. But either way it goes, the verdict can be reversed. Habeas corpus, and this is really the last ditch effort. So if you can't get appeals, or you get to that last appeal, the one last chance at overturning it, or at least getting the court to justify your detention or challenging it, is habeas corpus. An application for habeas corpus is a non-criminal civil lawsuit in which the defendant, now called a petitioner or plaintiff in this situation, asks the court for a writ of habeas corpus on the grounds that he or she is being unlawfully detained. In the event that the court finds that the plaintiff is unlawfully convicted or is being held without justification, the judge will order the individual to be released from custody. An individual filing a habeas corpus petition must be in custody and is required to file a claim within 1 year of having exhausted his or her state appeals. Um, Federal appellate courts determine whether the state court judgment is reasonable. Appellate courts rarely conduct a hearing on the facts. An appellate court will not retroactively apply law. And habeas corpus generally is not available to individuals who have failed to follow the rules for filing appeals in their state. So there's a time limitation. So you got to do it within a certain amount of time. And the habeas corpus ruling isn't retroactively applied to everything else. So it's pretty much just that case, just your case and your situation. Um, an individual generally may not file a habeas corpus petition that raises an issue that has already been included in a prior habeas petition, and may not file a second habeas petition that raises an issue that could have been but was not included in a prior habeas petition. What that means is, for habeas, you got to get it all right and put it in there and raise all your issues the first time. But that is it for chapter 14. So we've talked about everything from being sentenced, what type of sentences you can get from determinate to indeterminate. Mention let me talk about specific types of punishment. So you got imprisonment. That's when you go to jail. You have fines. That's when you're ordered to pay money or restitution. Then you have probation. What is probation? Probation is a situation where you are sentenced, but your active sentence is suspended and hanging over your head. So you're placed on probation, and while on probation, um, there's a certain set of things you're supposed to do and not do. If you don't do those things, and you're also doing supervised probation, that is, you actually have an officer who supervises you. So at any point that you fail to do something, you can be brought back to court, and that sentence that is suspended above your head can now be dropped on you, and you have to serve it. So you're actually not in jail, but you're actually in jail. So you're in jail without physically being in jail because you actually have a Department of Corrections number attached to you in your case file. So you now have a warehouse receipt, as they call it. And you also have a supervising officer who's watching what you do. A lot of times you have to come in periodically, whether it be monthly, or some people, depending on the seriousness of their case, may have to come in 3 or 4 times a year, and that's it. You might have to give a urine sample to make sure you're not using any illegal drugs. You have to stay clean and not commit crimes. A lot of times, if it's a type of crime where you have court costs or restitution, that's also a part of probation. So if you're behind in payments or you have a court indebtedness that's not taken care of, they can take you back to court for that, and you can be sent to jail. In other words, to serve the sentence that they actually imposed but suspended. So that's probation. So remember, probation, the sentence is suspended, but you're given a sentence, but the sentence is suspended, and you're not in jail. There's also doing probation what we call a shock sentence, or what we call split sentencing, where the judge may order that you do a fraction of your sentence and get out and be on probation. A lot of times it's what we call the weekenders in jail. So the judge can either say, yeah, you got 10 days, do the 10 days, you get out and you're on probation. But that's just your shock sentence to show you what it could be. You could do the whole full time instead of just 10 days. Sometimes they say, well, do your 10 days, but you can do it on a weekend basis. So you got 5 weekends, and you call those the weekenders. So that is probation. Then you have intermediate sanctions. Though that's when you're put on probation, but you have extra punishment, and that shock sentence is or what they call split sentencing, where you do weekends or do some days a part of your sentence, and then get out and you're on probation. That's considered an intermediate sanction. So intermediate meaning there's a mix of the regular supervised probationary punishment and like something extra, like maybe you got to do some of your jail time, or there's a community service requirement. Sometimes they have what we call day reporting, or where a person has to report to an officer or to an office daily to maybe do a GED. That's usually educational programs. So in a lot of those situations, especially with intermediate sanctions, they usually include sanctions that try to help the defendant out. So you've committed this crime because you didn't finish school, you can't make money. How about we put you in this program where we're going to force you to get your GED? Now, some of my clients look at it like, man, the man making me do this. I'm like, yo, you're on probation, and that ain't going to change. While you're on probation, just make the best use of it. If they give you the opportunity to get your GED, which will in turn turn into an opportunity to make more money, why not take advantage of it? Go, get it while it's free. Go ahead and take care of it. Do your community, doing community service. That's the intermediate. That can be an intermediate sanction. Do that. Serve. Sometimes you serve these places, and you may actually be, I guess, kind of showing them who you are and your true character. That community service at that place may turn into a job on the back end. So you have to consider that. But then let me see, after intermediate sanctions, which is a part of probation, then you have capital punishment, which we talked about. So that I just want to explain that real end to wrap up. But that is chapter 14. So you guys be good.